I guess I would say the rest of the panel may be right that it's too much to ask Congress to do anything about any of this, but at least we ought to recognize that Congress isn't doing anything about it, and as Michael just said, stop pretending that they're actually deciding these questions, and look more broadly. However, when we get to the agency level, I think we can expect the agencies to focus on this, because it can be an important part of the regulatory function, whether we're talking about specific product approvals or we're talking about rules or standards as a general matter. And so I would go a long way towards saying I would give the agencies lots of deference, provided they had adequate notice and a clear statement of what is preempted and what is not preempted, not simply coming out and saying everything in the world is preempted, because that's essentially what Congress has done. Now, the last point I want to turn to the request from Dan. I have a academic colleague who has at the bottom of his email, if this were legal advice, it would be accompanied by a bill. So this is not legal advice, Dan. But the first thing I would do is, if they won't write you a letter, write them a letter. Say to them, we are specifically abjuring from doing this because you have told us you can't do it. The second question on that is...
Done that.
Well, then you have something. And just send it certified mail, return receipt requested. The second question I ask is, are you forbidden from sending Dear Doctor letters out about that? Because that is not labeling. And one of the points that's been made in all of these prescription drug cases where the issue was one of warning is that there's nothing, I think, that forbids you, even in those cases where you have to get prior approval, from sending a letter to the doctor saying, by the way, you at least ought to think about this. Some people think it ought to be more than that, but you ought to at least think about that. After all, FDA can't regulate doctors. They don't regulate doctors when they do off-label prescription. I can't imagine, maybe they can. They can tell you you can't send a letter to the doctor, and maybe that's a free speech case that you ought to take up, Dan.
So one quick recap just on the presumption against preemption, because I think I do disagree, to search for disagreement in terms of that it matters. Because let me just give another sort of provocative example. In the hands of state courts, one thing we have to remember is in every single state save one, Michigan, the regulatory compliance defense, which is the state-based affirmative defense in these kinds of areas, is not dispositive. So if you show that you complied with the FDA regulation, it's some evidence of non-negligence. So state courts that are very rife with seeing this kind of regulatory compliance defense can sometimes see preemption as just a blunter form of that. And the presumption against preemption is an enormously powerful weapon for them to wield in these kinds of cases to then determine, without doing any further analysis, that there's no preemption. And that's why I think it actually is worth not just saying, well, it's there, but it never does any particular work. Particularly when you look at these state court cases, it's really revealing. Many of them that are preemption cases, they will invoke the presumption against preemption, and then they'll cite all the regulatory compliance defense state law tort cases supporting their view. So I think it does matter. In terms of how I would look at these things in the fresh start, I've come up with what I call an agency reference model, and this, I guess, relates to Dan's first question, because in this model, what it requires is actually that courts scrutinize the agency regulatory record. And Dan was providing a provocative example where the defendant manufacturers might be in a uncomfortable limbo period. One other example, just to put forward, is this same issue arose when the notice and comment period went out on the change being affected rule for drug labeling. Johnson & Johnson submitted a comment to the FDA at the time saying, when you weigh in on our change being affected, when we want to change the label or not, please respond in writing what your reasoning is as to whether you're accepting this or not. And the FDA just blew it off, right? In their response, they said, no, and we don't really see why what that is relevant for. Well, that's pretty shocking to me, because I think that's sort of the name of the game going forward. So likewise, I guess this isn't going to be very good legal advice. I think you're in a bit of a bind. I think you need to make the best record possible, and then that issue, my sense is post-Wyeth, these agency regulatory record issues are being litigated over in a way that they weren't as much before. So, you know, you push that forward and then make new law.
just what I'm here to do. It's what my CEO wants to hear. But we'll make new law.
And cite my article. That'll get you really far.
Putting on my former FDA hat for a moment, the reason why the agency, to quote Catherine, blew off the suggestion that it respond is they get about 3,000 changes being affected supplements per year. That's a different number than the prior approval supplement, where changes being affected, I do it, I tell the agency, they have to object. Prior approval, they have to tell me before I can go forward, okay? So you have an agency that is 10,000 people regulating 25% of the American economy, completely overwhelmed, besieged, beleaguered, attacked all the time, and on top of that was just given the responsibility for regulating tobacco. That made a lot of sense. And so the people we're talking about are the scientists who are in charge of ensuring that the drugs are properly labeled, keeping up on the science, et cetera, et cetera. And the reality is that the lawyers and the legal system and Wyeth versus Levine and their discussion about the agencies and the expectations of the agencies is a complete disconnect from the reality of the agency. So maybe the lawyers might think about preemption, but if you're a scientist, all you care about is making sure that the labeling is in accordance with the state of the art in terms of the science. You don't care at all. I mean, you don't even know what preemption is, by and large. These are brilliant people, PhD scientists, MD PhDs. FDA has more MD PhDs than, per capita than any other agency in the federal government. But they think as scientists. They don't sit there and think, oh, well, I need to respond in order to give them a preemption argument. And so when when Justice Pryor or Catherine says, well, or Alan says, well, I don't give the agencies lots of deference if they provide notice and comment and they really make a formal legal finding. Well, that's just not the way the interactions between the companies and the agencies work on a day-by-day, product-by-product basis. And it would absolutely paralyze the agency if every time they made a decision on a product-specific basis, they needed to promulgate a rule. It's a paradigm that the device law kind of tried to flirt with, but it's totally impossible and non-operational on a day-by-day basis. So we certainly have written them letters, and you make an interesting point, Alan, about Dear Doctor letters, but guess what? The FDA's definition of labeling includes Dear Doctor letters, PowerPoint slides, anything that has a textual connection to the product under the United States versus Cordell case from the 1940s. Now, there is a free speech challenge that Allergan has teed up, a very broad First Amendment challenge that Allergan has just teed up against the agency, literally taking issue with the agency's ability to prohibit off-label uses. That's pretty broad. And
that wasn't my challenge.
but
I was talking about sending Dear Doctor letters. That's
right.
it.
Okay, but you should understand that again, the horns of the dilemma. The agency says Dear Doctor letters are labeling and within their jurisdiction, and indeed, everybody thinks that the Bush FDA was the first one to assert preemption, even in courts. The first preemption brief that we looked at was actually filed by the Clinton administration, the Clinton Justice Department, in a case called Pfizer versus Bernhardt. And what happened was the plaintiffs in that case sought the remedy of forcing a company to send out a Dear Doctor letter. And guess what? The Clinton Justice Department came in and said, on behalf of the FDA, and said, that's our province. Sorry, no. You may not go to a court and ask a court for that. And that issue is preempted. So again, although many people think that it was the Bush FDA that started these targeted interventions, that
of course is the line between regulatory preemption and tort preemption.
Yeah,
and I did not intend to suggest that,
okay,
because that is an important line, and I view the issues rather differently in that context.
Okay.